Nancy Courtney is an associate lawyer in the firm of Howard Levitt and Associates. She practiced exclusively in the employment law field. She graduated from the University of Western Ontario with the Faculty of Law with her LLB and her Faculty of Arts with honor English and Literature. She's been called to the bar in 1987 and was awarded the Miller Thompson Sedgwick Labor Law Prize from the University of Western Ontario and was in the Dean's Honor List at the University of Western Ontario. She's participated previously in 2 Law Society continuing legal education seminars on pay equity. She'll be speaking today on the substantive changes to the law over the last couple of years.
Thank you, Howard. As we enter the 1990s, I think what we recognize is that the courts have lifted employment law essentially from a contractual foundation and placed it on a series of rights and obligations that aren't traditionally found in contract law. In this manner, the courts have really recognized the uniqueness of the employer-employee relationship. If we look at current developments in the area of employment law and look at these new rights and duties which have become the essential foundation of employment law, we recognize such newly developed concepts or newly re-emphasized concepts such as inducing breach of contract, ballpark justice, mere cause, and negligent misrepresentation. In the written materials that Howard and I authored, there's a very detailed overview of the particular developments. I'm just going to touch on some of the more significant ones for purposes of my presentation today. One of those is in the area of just cause for dismissal. Now, in the past, whether an employee's conduct would constitute cause for dismissal was determined solely by looking at the particular behavior that was involved in a certain case. And if that misconduct was held to constitute just cause in one case, then in every other case it would be just cause as well. This, however, is no longer the case. And what we see is that in a variety of ways, the courts are beginning to analyze cause contextually. So they're not looking at the misconduct by itself, but also looking at the circumstances surrounding that misconduct. So in the last decade, we see that the court decisions have increasingly departed from the concept of stare decisis with respect to just cause. And in the alternative, have examined cause in the context of what I determined to be primarily 4 areas. First, the nature of the company. Second, the employer's corporate culture. Third, the nature of the industry. And fourth, the nature of the particular position of the employee involved. Now, looking at the nature of the company, the recent case law reveals that conduct that would not amount to cause in a large office setting may nonetheless constitute cause in a smaller office setting. In one particular decision, Holden versus Phase Electric Limited, the court ruled that because the work of the plaintiff was so drastically different in style to that of the president of the small workforce where they worked intimately together, their inability to work together was sufficient to justify dismissal. Now, it's questionable that in a larger, more impersonal workforce, whether that ruling still would have been made. Looking at the company's corporate culture, the courts have recognized that this term involves certain things as developed standards of performance and conduct. In one case, the court noted that if the company in question had insisted upon hierarchical relationships, then an employee's actions in going over his boss's head to complain about something would constitute cause for summary dismissal. And that case was mentioned earlier this morning, Bell versus Cessna Aircraft. If, on the other hand, the employer had condoned an employee's behavior in going over a superior position's head, then such behavior would not constitute just cause for dismissal, and I refer you to the case of Clermont versus Sethum, Inc. Looking at the nature of the industry, yet another thing that courts have examined in looking at in the context of the behavior involved. What the courts have recognized in this area is that different industries require different skills and different resulting standards of conduct. For example, stockbrokers have been found to have a high duty of care, as have bankers in dealing with financial affairs. A case to look at in this regard, Ennis versus Canadian Imperial Bank of Commerce. Finally, the courts have examined the behavior in the context of the position of the dismissed employee. Now, for example, criticism by a non-managerial employee about his employer may not be sufficient to justify a cause, whereas comments that are critical of an employer made by a more senior employee would likely justify summary dismissal. Now, another concept that has been batted about recently is the concept of near cause. And traditionally, the courts have held in wrongful dismissal actions that if cause doesn't exist, then the employee is entitled to reasonable notice. And if there is behavior that is not sufficient to constitute cause, but is serious, it doesn't impact on the amount of notice to which that employee is entitled, and he would receive the same amount as an employee dismissed without cause who had an unblemished work record. Now, departing from this, some courts have started to recognize a middle ground, or the near cause principle, and in which case an employee who has misconducted himself in a serious manner but not serious enough to justify dismissal would have his amount of reasonable notice decreased as a result of this behavior. Now, in one case, it's been held that this principle must be limited to those situations where the cause relied upon has resulted in economic loss to the employer. Other cases have found that they apply only to situations involving willful wrongdoing on behalf of the employee in question, nothing that's done innocently. And in this area, I think it's important to realize that the law really hasn't yet crystallized. We have decisions by the Courts of Appeal in Saskatchewan, Ontario, and British Columbia rejecting the concept of near cause. But a recent decision of the Ontario Court of Appeal in Queensbury Enterprises, Inc. versus JR Corporate Planning Associates, Inc., the court held that it was not prepared to hold as a matter of law that the defendant may never claim reduced damages for wrongful dismissal, but that the court is satisfied that there should be no reductions in the circumstances of that case. So it sort of held open the door for the whole concept of near cause to be argued. I also refer you to the decision in Baudouin versus Canadian Corporate News, Inc., in which the Alberta Court of the Queen's Bench chose not to follow the decisions which recognize the principle of moderated damages, or chose to follow those decisions which recognize the principle of moderated damages, and chose not to follow the recent Ontario decision in Helbig versus Oxford Warehousing Ltd., which outright rejected the near cause principle. Moving on, another concept that we recognize as coming to the surface as we enter the 1990s, subsequently ascertained cause. Now, if misconduct is found to exist and is only ascertained after the employee is dismissed, the company may rely on the misconduct and not pay the employee severance pay. Now, often a company who has terminated an employee without cause and who wants to hold open their ability to rely on cause subsequently, should evidence come to the surface later on of some misconduct, they will plead it in their statement of defense. and they will be permitted to rely on it should they be able to flesh it out by the time the matter proceeds. Now, it's not necessary to pinpoint with accuracy the grounds for dismissal at the time of termination. It's enough if it's found that the misconduct which would constitute cause existed as of the time, even though it wasn't pleaded at the time. Now, I'll refer you to one decision in Carr versus Fema Holdings, decision of the British Columbia Court of Appeal. And in this case, the court really reaffirmed some recent developments in the law. In that case, the plaintiff was employed in sales on the basis of a one-year contract, and the contract had the following clause: if your work is not satisfactory, you may receive 1 month's notice or 1 month's salary in lieu of notice. And after working 5 months for a condominium corporation, most of the condominium units had been sold, so the plaintiff was terminated. Now, they proceeded essentially to a summary judgment in front of a judge in chambers, pursuant to Rule 18A of the BC Rules of Civil Procedure. And the chambers judge ruled that the defendant could not assert that the plaintiff's work was unsatisfactory, since it had previously indicated that her position was being terminated for redundancy. The Court of Appeal disagreed and ruled that an employer may dismiss an employee and give inaccurate reasons at the time of termination, provided that cause which would justify dismissal existed at the time of the firing. Regarding the case at bar, the Court of Appeal found that the chambers judge nonetheless came to the correct determination, given that the requisite facts for the utilization of the termination clause in the employment contract did not exist at the time of the termination of the employee. Since after the defendant had repudiated the employment contract, essentially firing her for a term other than for the reasons specified, which would trigger the 1 month payout, there was no longer a pre-existing ground for terminating the employee, which would allow the employer to end the employment relationship without providing proper notice. The area of breach of fiduciary duties and conflict of interest I won't touch on. I will just direct you to those in the material. What I would like to touch on is the area of constructive dismissal. And as a general principle of law, I'm sure you're all aware that a fundamental breach by the employer of a major term of the employment contract will allow the employee to treat the contract as being at an end and sue for constructive dismissal. Now, in the 1970s and throughout the 1980s, we witnessed a dramatic increase in the variety of situations in which the court would hold that a constructive dismissal had occurred. This liberal approach reached its pinnacle in 1987, and between 1987 and 1990, the court significantly narrowed the scope of situations in which an employee can successfully sue for constructive dismissal. Now, in the 1990s, the case law seems to reveal a return to the more liberal approach of the 1980s, or a beginning of a return to that more liberal application. And I refer you to a case of the Ontario Court General Division in Alpert versus La Ramcal Limité, in which the court was asked to decide whether an employer's actions in changing a compensation package of an employee to include a fixed bonus rather than a bonus based on net profits without a cap constituted constructive dismissal. By way of background, the plaintiff had been hired as the Toronto branch manager of operations in 1985, and under his diligent management, the branch's gross sales grew from $1 million to $12 million in a period of 4 years. In addition to his salary, he was to receive a bonus based on net profits without a cap, In '89, his employer said it's now going to be based on, it's now going to include a cap. He disagreed and sued for wrongful dismissal. The defendant, the court held that there should be a judgment for the plaintiff. He said the court ruled that the provisions for a bonus based on net profits without any cap was a fundamental term of the employment contract. And by imposing a cap on the bonus, the defendant was attempting to limit the plaintiff's participation in the company's growth. Now, it then goes on to look at the issue of mitigation, which I will get into in a little more detail later on. But the court in this case ruled that he did not fail to mitigate his damages by not accepting the new compensation package, because it would have been patently unreasonable for him to stay on, not knowing how much his compensation would have been reduced until the end of the period at which time the bonus would be calculated. So he was not obliged to accept the new package in an effort to mitigate his damages. On page 20 of our materials, we set out a number of major changes in an employment relationship which have traditionally triggered constructive dismissal actions. They're set out there, and the following pages describe the applicable case law. So I won't touch on those at this time, but I will skip ahead to the duty to mitigate, as this is closely tied in with these constructive dismissal cases where the nature of the employment contract is being radically changed and the employee is in a position of having to accept something that is less than what he initially bargained for, and what is the law applying to that. Now, one would assume that an employee's duty to mitigate in a constructive dismissal case would not require the employee to continue working at the job, given that the law normally requires him to resign and start his action for constructive dismissal. But some courts recently have ruled that it may not only be reasonable for the employee to try out the new position for a period of time, but that it may also be obligatory for him to accept the new position, even though he's been constructively dismissed. In the case of Mifsud versus McMillan Bathurst, Inc., the Ontario Court of Appeal ruled that a plant superintendent who had been transferred to another plant in the position of foreman, even though his remuneration and benefits were retained at the same level, had been constructively dismissed. The court went on to find that the plaintiff's refusal to accept the alternative position constituted a failure to mitigate his damages. According to the Court of Appeal, the fact that a transfer to a new position may, in law, constitute a wrongful dismissal does not eliminate the obligation of the employee to look at the new position offered and evaluate it as a means of mitigating damages. Further, where the salary offered is the same, where the working conditions were not substantially different, where the work was not demeaning, and where the personal relationships were not acrimonious, it was reasonable for him to accept the new position. So the court ruled that the plaintiff had improperly rejected the opportunity to mitigate his damages by maintaining an employed status while looking for a preferable position elsewhere. Another decision of the Ontario Court General Division, Sotnuck versus Lyfomed, referred to at page 35 of the materials, the plaintiff had a background in sales marketing, was hired by a U.S. company. Later, that U.S. company entered into a partnership with a Canadian company, and he was then to report to the newly formed partnership. He viewed the offer as unacceptable, resigned, and sued for constructive dismissal. Now, the court agreed that the plaintiff had been forced to become an employee of a new legal entity and that there was, in fact, a constructive dismissal. Nonetheless, the plaintiff had a duty to accept the new position of general manager to mitigate his damages, and they adopted the test of the Ontario Court of Appeal in Mifsud, and the court determined that the salary offered was substantially the same, the working conditions not substantially different or demeaning, and the personal relationships were not strained. The plaintiff, by rejecting a position which he was legally bound to accept, could not receive any damages at law. And any losses which he suffered by rejecting the position were of his own making, and he could not expect the defendant, in the court's view, to mitigate them. Another case which should be noted, the decision of the Ontario Court of Appeal in Davidson versus Alalix, a 1991 decision. In that case, the plaintiff was a microbiologist employed in the United States. He was lured by the defendant to a very special position at its in a research department in its Canadian plant. When the defendant very early on purported to change the position, the plaintiff alleged a breach of his employment contract and sued for damages. After finding that the plaintiff had been constructively dismissed, the court went on to look at the issue of mitigation, and the court distinguished that case from the Mifsud decision and stated, Madam Justice McKinley recognized in Mifsud that an employee who has risen through the ranks in his company was significantly different from that of a supervisor or an executive employee who was originally hired away from another employer to fill a specific provision, as the plaintiff was in this case. The court found that it would be patently unreasonable to expect the plaintiff to accept the lesser position offered to him by the defendant instead of the managerial position that he'd been hired to fulfill. The court found that the offer of alternative employment could not be viewed as a reasonable opportunity to mitigate damages. Finally, in this area, Stephenson versus Globe and Mail. In that case, the plaintiff was the managing editor of the Globe and Mail. When he was informed he was being removed as a managing editor and being offered an undefined position as an analyst in Washington, D.C. Once again, sued for wrongful dismissal, and the court held that he had been dismissed constructively. The court went on to consider the issue of mitigation of damages and looked at Mifsud. The court determined that the plaintiff was not required to accept the analyst position because it involved a definite decrease in compensation, and the details proposed to the plaintiff were indeed vague. It may have been that had the defendant acted in a more definite manner, the outcome of the case may very well have been different. Looking at the area of damages, one of the things that are being or have traditionally been claimed as damages are benefits, employment benefits. And here, if we look at the case law, we see that it has gone all over the place with respect to benefits. A number of courts have awarded a lump sum payment to cover the loss of the benefits or a specified group of benefits. Other courts have awarded the company's cost of those benefits. And some cases have held that no, what you compensate for is the employee's cost of these benefits, which are going to be completely or definitely higher than the employer's because the employee is not going to be in the position of participating in a group benefit program. Now, until recently, the overwhelming majority of the decisions only awarded the plaintiff's actual expense in replacing the benefits. So if he was covered by a spouse's plan or he just didn't bother to replace the benefits, then he suffered no loss and he was not compensated for replacing the benefits. This now has changed, and we find that the court is fixing the value of the benefits at the employer's replacement cost. There are a number of cases in this area. One you may look at is Davidson versus Alex. Another thing that companies want when deciding whether to terminate someone are going to want to consider is the whole issue of short-term and long-term disability entitlements. I've discussed one case, Trial versus Allied Chemical Canada Ltd. at page 41 of the materials. There are a number essentially holding that if an employee becomes or has an entitlement to short-term disability or long-term disability by becoming disabled through the notice period, then the employer will be liable for the cost of those benefits he would be entitled to, even if it has sought to discontinue his coverage under those types of benefits. And I'll just make note of the fact that a new heading that we see under the rubric of damages and the things claimed, a site allowance, and there's a case referred to, Wilson versus Bentall Group Limited, which discusses that type of allowance. An overseas allowance or a local allowance discussed in Hughes versus Thai Communications Canada. Now, development that warrants a little closer scrutiny is the whole concept of ballpark justice. And a number of recent decisions have found that if the company's severance arrangements made at the time of the termination of the employee were fair and within the range of reasonable notice, the courts will not provide a greater amount. Following this approach, one court found that 3 1/3 months was not reasonable for a senior employee, whereas 8 months was. Other cases have found that, if applicable, the range of permissible error would be 3 months, and that case is De Freitas versus Canada Express and Transportation Ltd. Just brief notice of the case Spooner versus Ridley Terminals, Inc., a BC Supreme Court decision. That court examined the whole area of ballpark justice, or the reasonable offer of the company doctrine. It recognized that the doctrine originated in Ontario in 1985 and imposed an initial threshold onus upon a plaintiff to show that the employer's offer was unreasonable. The doctrine specified that if the period of notice under the severance arrangement was reasonable, although lower than what a court would have awarded, the court would not interfere. Now, the court in this case rejected this doctrine as an abdication of its responsibility to set specific damages. And in this court's view, a reasonable offer will only go to the question of legal costs. If the defendant made what is considered to be a reasonable offer, it would assist the company in its argument for reducing any assessed legal costs. The court thus ordered the defendant to continue to pay the plaintiff her monthly salary and retainer health benefits for a period of 12 months. The monthly payment would be reduced by 50% in the months following the plaintiff's reemployment and at the conclusion of the notice period. I won't go into wrongful hiring, but that is also set out page 48. In the area of costs, I'll refer you to one case, Mant versus Buckerfields Limited, a BC Supreme Court case in which the plaintiff was a manager of a defendant's retail outlet and was dismissed after 12 years of service with the defendant for cause. Approximately 2 months prior to the termination, the plaintiff's wife left him without warning, and the plaintiff suffered a nervous breakdown. The psychiatrist described his condition as murderous at times, suicidal, and deeply depressed. Between this event and the termination, the company underwent a new administration after a takeover, and although the previous administration had advised the plaintiff to take as much time as he needed to get back on his feet, the new administration placed a greater emphasis on following established policy manuals and strict accounting controls. Reacting to rumors that the plaintiff had a financial interest in the outlet that competed with the defendant's store, the defendant met with the plaintiff to discuss it and ended up terminating him. Now, although the court found that the plaintiff had engaged in a number of practices that were significantly serious to warrant summary dismissal, when dealing with costs, the court stated that in the ordinary course, the defendant would have been entitled to its costs, but the cold-blooded and insensitive way in which the defendant dealt with the plaintiff when he was already suffering from emotional turmoil justified penalizing the defendant by depriving it of costs. and the court in that case ordered each party to bear its own costs. That is my summary of the more detailed paper provided in your materials. Thank you.
John Laskin is a graduate of the University of Toronto Law School. Called to the bar in 1971, he is currently head of the litigation department at Davies, Ward and Beck, and formerly counsel to the Ontario Human Rights Commission and to several provincial public inquiries, including the Royal Commission on Health and Safety Effects of Asbestos and the Ontario Inquiry into Motor Vehicle Accident Compensation. He's taught in the bar admission course and at the University of Windsor Law School. He's a member of the Canadian Human Rights Tribunal since 1985, a fellow of the American College of Trial Lawyers, and a director of the Advocate Society. He's active in public interest advocacy, and Mr. Laskin is an author of many papers for legal education seminars. He's here today to talk about litigation strategies from the standpoint of the employee, and I'll be dealing with the same topic from the standpoint of the employer.
Thanks, Howard. I told Howard not to introduce me, but at least the one thing that introduction shows is that I'm not a specialist in employment law. So you get today a generalist, and I have to tell you that as a generalist, as a litigator, I am finding increasingly that this is yet another area of the law in which it is becoming ever more difficult and perhaps even dangerous to dabble in. I mean, I think you heard Justice McLachlin and Justice Finlayson talk about all the changes in the law and so on, and the reality is that this is becoming a very difficult area, I think, to practice in unless you are like Howard or others who really specialize in it. Having said that, with that caveat, I wanted to talk to you about a few practical suggestions that have worked for me in conducting wrongful dismissal claims. Please feel free to ignore any or all of them. I don't propose to talk about law. I'm not going to mention one case, and I don't propose to talk about legal principles, because that's not the purpose of my talk here. I'm going to assume that the client I'm talking about is a non-unionized employee, and I'm going to assume that he or she comes for advice either on the eve of termination or following his or her termination. And before I become a little specific, let me just say this, that in acting for plaintiffs, I have invariably been struck by two things which may appear obvious to most or all of you, but which I think are worth mentioning. The first is that the non-economic consequences of being terminated are often at least as profound as, and sometimes even more profound than, the economic consequences. The loss of one's job, and I don't think I need to tell anyone here who practices law, but the loss of one's job can be a horrible blow to a person's sense of self-worth, to a person's dignity and self-esteem, not to mention the perceived loss of reputation amongst friends and even family and so on. And so I've always considered it important in acting for a plaintiff not simply to treat the claim as a money claim, but to have some understanding of the non-economic consequences as well, and as to try to do something to relieve against those non-economic consequences in conducting litigation or negotiation or whatever. And some of the things I'm about to suggest, I hope, try to address those kinds of considerations. The second thing I've always been struck by is how little dismissed employees understand about what the court can, or perhaps more importantly, what the court cannot do for them. And maybe that says something about the rationale of our law in this area, but it seems to me that plaintiffs really don't understand very well that courts can't reinstate them, that employers can terminate them for any reason they want as long as they give them a reasonable notice period, and that once terminated, an employee has this mitigation obligation which can erode or in some cases even eliminate a claim against an employer who he or she feels very aggrieved towards. Those are often foreign concepts, I think, to plaintiffs or potential plaintiffs, and I think when you're acting for them, you need to take time, a lot of time, to outline at the beginning the broad principles of law that apply in the area. Now, let me become a little more specific. The first area I want to talk about is what I call the importance of fast action. Wrongful dismissal claims don't get any better with the passage of time. And in fact, I think this is one of the areas in which the passage of time is particularly prejudicial to plaintiffs. You've got to act quickly, and you've got to do what you can to reduce the natural advantage that an employer has because of the delays in our court system. And you have to, I think, remember that if your client is not employed and he can't find another job, even a month may seem like a lifetime to your client. So, some practical suggestions. I think there is merit in putting pressure on a defendant immediately upon being retained by making an immediate assessment and making an immediate offer to settle. And I like in my offer to settle letter to indicate to the other side that this offer should be treated as a Rule 49 offer in the event that a lawsuit is subsequently started. Because I like to be able to put some cost pressure on the defendant even before you start the litigation. So that's number one. Number two, I think there is merit in asking immediately from the employer for a positive letter of reference. It's probably the best time to get it because the employer is probably feeling a little guilty, or he may be feeling embarrassed, or he may even be feeling sad about having to let your client go. Take advantage of it. Ask for a letter of reference that is positive. I mean, it will have the corollary effect of helping a little bit to restore your client's sense of self-worth and self-esteem. And if you don't get it, make sure you've asked for it on a with prejudice basis. If you don't get it, and if the request is reasonable and is refused, then I plead it in the statement of claim. If you haven't got reasons for termination, I think you need to ask for them up front, but I think you need to do that after you've asked for your letter of reference and not before. I mean that, but there's no harm, and indeed it may become very tactically advantageous down the line to have pinned the employer down early on to the reasons why it has allegedly terminated your client. It's a lot harder for employers at the trial of the action to try to supplement those reasons, even if legally they're entitled to do so. The impact on a judge is generally lost. Next, in my view, one should insist on immediate payment of any Employment Standards Act payments to which your client is entitled. Don't deal with those payments as part of your overall settlement negotiations. The employer has an obligation, statutory obligation, to make the payments immediately. And as you know, there's no general just cause exemption. So there has to be willful misconduct. And I mean, there's obviously a big corollary advantage. If you can get a little money into your client's hands very early on, you at least relieve a little bit of the pressure of having to make a quick settlement that may be disadvantageous. And again, if the employer isn't forthcoming immediately with a statutory obligation, I plead it. If there is no immediate settlement, then I encourage you to start the lawsuit right away. Don't get derailed in protracted settlement discussions. And if you haven't already done so, at least serve a Rule 49 offer with your statement of claim. I mean, I think you are really doing your client in a wrongful dismissal action a huge disservice if you don't put cost pressure on the employer from day one. So serve a Rule 49 offer right away and make sure it's a reasonable one. If there is a defense of just cause and the allegation is fairly general, I don't personally think there is much merit in wasting time on a motion for particulars, even though you could probably succeed on a motion for particulars. I just think you're wasting your client's time. I'd go on to discovery, get on to discovery, get your particulars on discovery, pin the client, pin the employer down on discovery. And sort of lastly in this area, If your client is still unemployed by the time of the pretrial, there is nothing the matter with asking the pretrial judge for an expedited trial date. I think you will find most judges very sympathetic to giving you an expedited trial date in a case where your client is still unemployed. And there's certainly no harm in asking, and I have got those orders on occasion. Okay, the next area I wanted to cover were just some points about pleadings. If you get that far. I personally don't like boilerplate wrongful dismissal statements of claim. I think it is very important to personalize the claim and build up your client in the statement of claim. I mean, like any other statement of claim, use it, as our Chief Justice of Ontario is fond of saying about factums, and it's a wonderful phrase, to whet the appetite of the judge. And I think that's what a statement of claim ought to do in any case, but particularly in a wrongful dismissal case. And especially, of course, if you're trying the case by judge alone, which I will have something to say about later on. As Justice McLachlin said this morning, be creative. Think beyond the contours of contract law and so forth. I always seek in a statement of claim in a wrongful dismissal action not only damages for wrongful dismissal, but I also ask for a declaration that the plaintiff has been wrongfully dismissed. Now, you may ask why I do that, because of course if the case goes to trial and if you're successful, then the court's going to have to make a finding that your client's been wrongfully dismissed. But what if you're in settlement negotiations? If the employer is not prepared to acknowledge that he has wrongfully dismissed your client, by acknowledging that, then you have gained yourself, in my view, some valuable cost protection against any monetary offers that an employer may make under Rule 49. Second, a settlement for your client in money terms only may well satisfy or partly satisfy your client's economic claims, but it is not necessarily going to do anything for your client's loss of self-esteem or his loss of self-respect or his loss of dignity. What's going to do that for him is some acknowledgement by somebody, either a court or his employer or both, that he's been wrongfully dismissed. And therefore, I think that it is really important to seek that relief. And of course, in terms of future job prospects for the client, I mean, if he can show that there's been a recognition that he was wrongfully dismissed, that may well have some positive effect on future job prospects. Next, notwithstanding what the Supreme Court of Canada said about 3 years ago, I still think there is some merit in making a claim for damages for mental anguish in an appropriate case. I like to use it as one of my good friends would say, a wild card in settlement discussions. I think in some cases it will make employers more likely to settle for a reasonable or substantial notice period, because the employer may fear an adverse finding on mental anguish. But if you're going to make that claim, you've got to do some spade work. It seems to me you've got to get your client to a counselor, a professional counselor right away. And you can't just make the claim in the abstract. Get your client to his family physician, get his family physician to refer him to a psychiatrist. Then it's covered by OHIP, and you've got some expert evidence to support the claim. And what I've also found is, and maybe some of you have found it, that there is sort of an added benefit for the client in doing that. I think the counseling, I mean, clients don't want to go to counseling necessarily, but you tell them they've got to go there because it's going to help their claim. And once they're there, I think a lot of them find that it indeed helps them to overcome the sort of social and psychological consequences of termination. So I commend that to you. Although our courts are conservative on this issue and probably haven't come to recognize it, I think we as the lawyers acting for plaintiffs need to pursue in appropriate cases allegations of implied terms that your client had a contract until age 65. Now, I realize that that's sort of foreign, and we've just heard two judges talk about balancing here and about reasonable notice and so forth, but it seems to me that someday one of our courts is going to hold that. And there are some situations in which I think are amenable to that kind of allegation. I mean, let me say first of all that for those employment contracts that are written and not oral, many of them don't seem to exclude implied terms. I mean, they're not often drawn as tightly as tight corporate commercial contracts, so there is scope for making this allegation. The kinds of situations I think are amenable to this kind of allegation are the following. Number one, where a company where all the employees are sort of said to be part of family or kind of treated like family. You know the saying, you're here for life, and you know, we're all just one part of big one happy family, which of course a promise that was made when the client was hired and times were good, and a promise that's invariably forgotten when firing comes about and times are bad. But that's one situation. A second situation is where the employer has both union and non-unionized employees in the workforce, and that there has been sort of a general progression over time that they are treated in lockstep, so that there are equivalent salary increases, equivalent benefit packages for union and non-unionized employees, so you can try to develop the argument that your non-unionized workforce should have the same kind of security of tenure as well, that kind of situation. And perhaps finally also in a case where the employee's compensation may include residual payments over a long period of time. Somebody who works for an insurance agency, for example, sells you a whole life policy for 20 years or something, and gets compensation for the premiums you pay for the next 20 years. You can try and develop some argument out of that, that it's implicit in that he'll be around to be employed for the next 20 years, that sort of argument. Anyway, I think all of that is worth trying. The next area I wanted to talk about a little bit is mitigation, which I think is a very important area, and as I said before, not often understood by dismissed employees who many times feel they have no obligation to mitigate their losses. So first and foremost, you've got an education job with respect to the law. But I think more than that, employees who are dismissed because they're disconsolate and they're depressed and they haven't got a lot of energy and a lot of motivation in many cases. They're just not motivated to do much about looking for other jobs, and even if they do, they don't seem to be very motivated to keep a very good record of what they're doing. So I think you need to build up a mitigation file from day one. You should be drafting a CV for your client, and then I think you should try to monitor your client's mitigation efforts almost on a monthly basis. I mean, drum into him that he's got or her that you have to keep every letter that's sent and every letter of rejection you get and every ad you've responded to and every memo of and make a memo of every interview and keep track of all your expenses and so on. But I think you have to work at it. It's something you got to keep track of and take the initiative to do. I consider this whole issue to be much more than just a legal issue, personally. For those of you who, like myself, sort of believe in the good person, bad person theory of litigation, I think it is important at trial to be able to show that your client has made an honest and sincere effort to mitigate. I think the failure to do so may well affect the notice period, even apart from legally. I mean, I think there's a psychological impact on the court. If the court believes your client has not made genuine efforts to find another job, then I think you run the risk of losing the natural sympathy of the court. And don't forget, when acting for a plaintiff, you almost always have the natural sympathy of the court starting out in a wrongful dismissal action. I think it's something you can't underestimate, and I think it's something you've got to maintain and try to preserve. So you don't want to get your client in the position of the judge thinking that he's abused the system. So mitigation becomes important. I've often found that dismissed employees who are very depressed immediately want to go out and start their own business. They think that's the solution to all of their problems. just like we in the big law firms sometimes think the solution to all our problems is to leave and go out and start on their own, but they sometimes think they want to start in their own business, and sometimes I think you've got to caution them against that, because I think it can be a bad strategy, because a judge may not quite view it that way and may view it as a dereliction of a reasonable effort to mitigate by finding a comparable job. I think, and Howard makes this point very well in his book, I think it is better to wait a few months, and therefore in a much better position to be able to show that another job is just not realistic. I think it is worth considering in an appropriate case getting expert evidence on the existing economic conditions and their effect on the labor market. Nothing the matter with trying to, that evidence is not so hard to come by and is worth putting forward in a proper case. I think it's bound to have an effect on the court. Okay, let me turn to another area, which is settlement negotiations. I think there are a few cases in which it is in the plaintiff's interest to go to trial in a wrongful dismissal action. It's not just a cost issue, it's a length of time to get to trial issue, it's a whole bunch of other things. So your object is to settle. Of course, your opponent knows that he has a tactical advantage which the delays in the court system have given to him, and you got to do what you can to combat that. And of course, one of the main ways to do it is the use of Rule 49 offers to put the maximum pressure on defendants, but that means the offers have to be reasonable. Your object always is to settle in a way that achieves a measure of double recovery for your client. I mean, ideally, you want to achieve a settlement that will give him or her overcompensation, i.e. you want to get more than the equivalent salary for the time your client's been out of work, if you can do it, if your client's going to get another job. Remember that you've got one advantage in that negotiating process. The one advantage you've got is that you know better than your opponent when your client's about to get another job. And you've got to play on that advantage. And I think you should plan your settlement strategy on that basis. Now, of course, it depends on having a client who's going to be employed within, the notice, what would otherwise be the maximum notice period. But at some stage, you've got to make an informed assessment of the likelihood of that job coming through. And in my view, you have to monitor the situation very carefully with your client. If you don't monitor it, what's going to happen is your client's going to come to you and tell you he's just got a new job. And the cat will be out of the bag, and the defendant will know it almost as quickly as you do, and you've lost your leverage. So it seems to me this is an area in which you can gain some significant monetary advantage for your client, but only if you're really monitoring the situation carefully. Use the settlement process to get things that you cannot get at trial. I'm thinking in particular of letters of reference and relocation counseling paid for by the employer. It's obviously in the employer's interest to provide those things because it reduces the employer's exposure, makes it more likely your client's going to get a job. It's in the plaintiff's interest to get these things. They're in part monetary interest and non-monetary interest. There's also some other advantages I think plaintiffs have in this process. Your client is not in the workplace anymore. The employer always has to be concerned about the effect of wrongful dismissal litigation on his existing workforce and on the morale of his existing workforce. And he always has to be concerned about the effect on his customers or his suppliers or so forth, so that there are strong reasons sometimes why employers will really want to avoid litigation, and certainly litigation that has a high profile or gets around the workplace. And again, that's just a tactic that you can use to your advantage in settlement discussions. I'm no tax expert, but the one thing I've learned about this business is that you better know something about tax law, or at least know who to send your client to get some tax advice, because there's obviously some pretty important tax planning that can be done. So if you don't have access to a tax lawyer in your firm, get your client to an accountant. Let me deal, there's two other areas I want to deal with, and I'll deal with them quickly. One is dealing with allegations of just cause for dismissal by defendants. I'm not going to deal with this in an exhaustive way because, of course, a lot of this just turns on good advocacy and good examination for discovery. But let me suggest the following. Number one, don't be intimidated by a defense of just cause. First of all, as I think most of you or all of you know, judges are pretty reluctant to make such a finding without awfully compelling evidence, particularly in these times. Second, in my experience, there is many a just cause defense that looks good on paper and absolutely dissipates in practice, either well before trial or at trial. Employers are very reluctant to get their staff embroiled in a wrongful dismissal action. So employers may well put in a statement of defense as part of a just cause defense that your client couldn't get along with his fellow employees. Fine. Ask for the names of all of those fellow employees. Ask for the substance of their evidence. Go after them. And my guess is that that allegation will disappear pretty quickly. And one might say the same thing about customer complaints as a basis for a just cause defense. Go after that. Employers will not likely want to get their customers involved in being witnesses in a wrongful dismissal action. You often see a general incompetency defense. Try asking for production on discovery of all of the documents relating to all of the projects your client has been involved in or worked on in the last 5 years, and see how long the employer tries to maintain that kind of defense. I mean, I think the overall message is make it as onerous and as burdensome as possible on an employer when he alleges just cause. Make it as difficult as possible in the production and discovery stage, and with the object of getting rid of that defense as early on as possible. Since it's running late and I haven't given Howard a time, let me just say one last point about trials. It seems to me almost every wrongful dismissal action in Ontario is tried by a judge alone, and quite frankly, I'm not sure why that is. I have to confess to you, I have not done a scientific study of whether jury awards give more or less notice than judge awards, and I doubt you could really measure it objectively or statistically or scientifically. But quite frankly, personally, I'd much rather take my chances with a jury than with a judge. So I serve jury notices in wrongful dismissal actions on behalf of plaintiffs. I'd be interested to know what Howard's viewpoint is on this, because he's had much more experience than I have on it. But my sense is that juries tend to be more sympathetic than judges on the length of notice periods, especially where you're not too worried about sort of your client's conduct or misconduct. And I guess there's a corollary advantage to jury trials, and that is in some places in this province you can get them on an awful lot more quickly than you can a judge-alone trial. So I'm a believer, and I commend you at least thinking about serving a jury notice in wrongful dismissal trials. So I should probably stop now, Howard, and let you have something to say. Thanks very much for your attention.
I think we as litigators put too much emphasis upon a case's likely outcome at trial. Certainly that's a factor insofar as it will impact and shape both parties' view of what's reasonable and accordingly what they're likely to settle for. But you have to be cognizant of the fact that probably more than 99% of cases settle sometime in advance of trial. So what you should focus on from both sides' standpoint is what will influence a favorable settlement. Now, in doing that, from the standpoint of the employer from which I speak today, you must put yourself in the mind of the employee and understand their psychology in determining, for example, whether to allege cause, what offers to make, and when to make them. What are the employee's motives? Will they include, and of course it's rather idiosyncratic in some cases, but obtaining money while they're still employed, or unemployed, concern from their apprehension of the company's comparatively deep pocket, concern for their own reputation, desire to maintain a positive relationship with their employer and obtain a positive reference, concern at the fact that the lawsuit might create difficulty in their reemployment, and uncertainty, obviously, as to the result. Similarly, from the standpoint of your client, you have to address with them, I think, at every stage of litigation, a broad host of factors. Now, some of those factors, which are dealt with at page 6 of my paper, include the company's potential liability. Generally, I will not be referring to my paper. I want you to just relax and enjoy to the extent possible and not be paper bound. The strength of its case, the amount for which an employee is likely to settle at different stages of litigation, the effect that litigation by that employee will have on the morale of the remaining employees, the impact of alleging cause in the morale of the remaining employees, the effect that litigation may have on customers and suppliers, the effect that litigation may have on potential customers and suppliers, and ultimately the cost of litigation. Now, one of the first questions you have to deal with is whether cause should be alleged. Generally, it should not be if there's no real basis for it. Court awards have provided damages for mental distress and punitive damages in situations when cause is frivolously alleged, even post the Vorvis decision of the Supreme Court of Canada. Solicitor and client costs. The court may be antagonized by the allegation with a host of ramifications. It's arguably, at least, professionally improper. It makes relevant all aspects of the company's practices that could impact on the allegations. To give one example, I had a case where I acted for an employee and the company pleaded fairly broad and general incompetence on this plaintiff's part. So what I did in response, while denying it, is saying that to the extent this employee had any difficulty, it related to difficulties in the employer's operation in 39 specific areas that were set out in the reply. And then, of course, as John suggested, I asked for production of a host of company confidential documents in those 39 areas, and particular facts, set up about 12 days of discoveries in advance. And as you can imagine, given the magnitude of the case, and for that matter, most wrongful dismissal cases, the case settled relatively early thereafter. There may be areas, acting from the standpoint of the employer, that you simply don't want to expose in your client's operations by making them relevant. For example, a lot of employment counsel in these times almost automatically plead the Bohemian defense of economic difficulties. Do you really want to make the various details of your client's financial affairs relevant to a comparatively small wrongful dismissal action? As a judgment of Mr. Justice Bard, I just can't remember the name, but it involved an engineering firm, made clear a couple of years ago, once you plead Bohemian, anything about the employer's economic decision-making becomes relevant. Now, having said that, with respect to the downside, my general view is if you have some basis for cause, you should generally plead it, although again, being cognizant of the downsides and what cause you might not want to plead. The Court of Appeal, in a recent decision, opened the door again, as Nancy Courtney made clear, to the doctrine of near cause. There's a prospect that after termination, other employees will be more forthcoming, and an investigation may provide you with proof of what you suspect. And there's a reality. Faced with even a slim prospect of losing, employees will generally accept a much reduced settlement out of all proportion to their prospect of losing. The reason is, first of all, to make the case viable at all, they have to remain unemployed for a certain period of time to incur sufficient economic loss for a tenable wrongful dismissal action. Faced with that prospect and the reality that this is the time they can least afford to fund a wrongful dismissal claim, you're now exposing them to their lawyers, seeing a cause case, probably asking for a larger retainer than she or he may otherwise, and the prospect ultimately of paying the employer's counsel's costs as well. It's a substantial deterrent to continuing. The other thing you might want to do is have your client explore other areas of cause. For example, did the employee misrepresent their qualifications or backgrounds or circumstances in leaving their previous employer and joining your client? According to a 1917 decision of the Supreme Court of Canada, and most recently the Cornell and Rogers Cable Systems case, that is cause for discharge, even if not ascertained during the employment relationship. As well, your client's internal auditors may be able to establish the employee had falsified their expense account or made various long-distance telephone calls at the company's expense. Those are possibilities if your client wants to make those allegations and is comfortable with exploring those possibilities. But if you're going to plead cause, I suggest doing so very specifically. If it's too general, the Ross and Phillips Electronics case found that plaintiff's counsel can examine multitudinous issues going to any possible allegations of cause. John said, quite rightly, he doesn't make a motion for particulars. And here's another good reason, in addition to the good reasons that he listed. You should also consider whether to proceed with a counterclaim. Now, we don't often see counterclaims by defendants based on implied duties. But there's a body of law suggesting that just as, of course, the employee can sue, take action for breach of the employment contract, so can the employer. The House of Lords decision of 1957 in Lister and Romford set out a number of the implied duties of employment, but they at least include claims based on disobedience, claims based on lack of honesty, and even claims based on a lack of diligence. Certainly claims that are sustainable in a significant portion of wrongful dismissal trials today when there's any type of viable defense. Another area I think you have to examine with your client at the time of termination, this is another flip side of John's comments, are the area of references. What reference does the employer want to provide to that employee? Now, obviously, an allegation of cause is inconsistent with a positive reference, and for that matter, a person ostensibly calling for your client for reference might actually be calling to gather evidence for the case. On the other hand, if no reference is provided, John will plead it, which is a good practice, and the potential damages obviously will increase with the period of unemployment. There's other problems. Courts have awarded damages for mental distress and punitive damages for poor references. And there's a possibility of creating suits for defamation and negligent misrepresentation. And there's a good guy, bad guy test that John refers to that may impact on the judge in ultimately making a determination, even on the issue of notice, the subconscious bias created by the lack of a reference of a deserving employee. And I've seen that referred to in more cases than one. What I recommend doing, particularly if the employee has retained counsel, is to negotiate the provision of a letter of reference on a without prejudice basis to the lawsuit, even if cause is going to be alleged. Let me talk about some matters that arise during the litigation itself, or at least during its currency. How many of you have considered a motion for summary judgment? If you're acting for the employee and cause isn't alleged, it's a rather obvious initiative we should all consider taking, particularly since, as John says, time is of the essence. What about if you're acting for the employer? If cause, again, is not alleged, but you plead a reasonable offer, or you plead a sufficient payment, there's no reason why you shouldn't be bringing a motion for summary judgment if you're confident in your position. Subject again to the issue of timeliness and whether you think that that might ultimately result in a settlement. that's more advantageous simply as a result of the passage of time. But if that's not really a concern, or you're quite confident of your offer or payment in, then make a motion for summary judgment. What about after the discovery process, even if cause is alleged? I'm bringing a motion right now in such a circumstance because of admissions adduced during the discovery process, where I'm confident that already we've established sufficient cause based, in fact, only on the plaintiff's discovery that our client hasn't been discovered yet. Why wait for trial? Other matters to consider: preparing your own job search. Obviously, the employee has an obligation to mitigate, but you should have your client involved in recruitment, that person from the personnel department, make their own list of all available jobs listed in the relevant newspaper in which the employee should be looking during the period in which the employee should be applying. If you can find positions the employee has not applied for and obviously should have been, and I don't mean one or two, but I mean if the vast preponderance of positions that are obviously listed in the newspaper for that kind of position, and the employee hasn't applied for any of those positions, you have a very strong argument, not only that the employee has failed to mitigate, but that they could have found work, which is, of course, in the Red Deer and St. Michael's decision, Supreme Court of Canada, the onus is on the employer, but that they could have found work because of the availability of positions if they had been looking. What about executive search firms? I had a recent case with one of the audience in which the adjudicator, it was a Canada Labor Code adjudication, found, we called an expert witness, an executive search consultant, who testified that during the relevant period of time, jobs were available and this employee should have been able to find work in a 4-month time frame. And ultimately, the adjudicator relied upon that in finding that 4 months was the maximum notice that could be provided, although, in fact, the case law for similar positions was generally higher than that. But of course, the best evidence is the evidence called a trial, not an unrelated decision in different circumstances, perhaps from different provinces. So that's something you should consider with respect to defending a mitigation position. I found sometimes when you're doing that sort of search, sending employees counsel the odd clipping might put some pressure. Wondering what else might be in a repository of clippings, particularly if they haven't applied for the clippings that you've sent, and particularly if they're obviously clippings that they should have applied to because of their size, because of their location in the relevant newspapers. It's interesting how many cases settle after that particular strategy. If it doesn't work, then check at discovery as to when, and perhaps beyond discovery from your own inquiries, as to when that employee actually applied for that job that you sent them the clipping of. The other thing is, where do they apply? Discovery can be a very useful opportunity to get that sort of information. Did they apply to all competitors? Did they apply to previous employers who presumably they had good relationships with from their evidence up to that point in the discovery? Ask them about their skills as deduced from the resume. Have them talk rather generically about what types of jobs those skills enable them to do, and then, having obtained those admissions, narrow in on whether and why they haven't applied for those types of positions. Have they applied in just the narrow market area in which they used to work, or have they, as many courts require them to, look beyond that, particularly after a few months when it's clear positions aren't available in their own market area? Your executive search firms that your client deals with on a regular basis should contact the employment and assist the employee in question, assist them in finding work, because obviously that reduces the damages. And if they don't go to the interviews when requested to, obviously that's very good evidence that they haven't been mitigating, and that's very direct evidence they haven't mitigated. John asked about a jury notice, and I wasn't going to touch upon that, but I will because it is an interesting point, because he asked me to. There haven't been many cases, so I don't have really any more experience than John does, perhaps one case more, but that's about it, on jury notice was in the case that our office did and the case that I've seen reported, the employee received not much more than minimum standards. Why is that? Well, I think there's two reasons. First of all, juries consist in some cases of bargaining unit employees, and bargaining unit employees have no right when terminated, assuming it's a layoff or it's a termination that they can't be actually reinstated for, to more than employment standards minimum. So that's their expectation historically. The second reason is, and this may change, it may have already changed since these couple of cases a few years ago, most employees expect, or many employees expect, little more than minimum standards. Because except for the last few years, and I mean few, what are employees experience? Traditionally, they get terminated on the old 2 or 4 weeks notice. So why would this employee, the plaintiff in a particular case, receive more, in their view, than they received themselves when they were terminated from their job? And juries don't generally consist of the management and executives who are used to 12-month severance payments or months per year of service or whatever some people's expectations are, however erroneous in fact, as to proper severance. Having said that, which is simply empirical, obviously a jury notice should be looked at from a plaintiff's standpoint in a case that's particularly heinous in terms of the employer's treatment of the employee. And a jury notice should be looked at from the employer's standpoint in the type of case where significant notice might be provided as a matter of law, but proceed at your peril. Because, of course, there's little predictability. And if you look at the American jury awards, I only know of the state of California, which is doubtless anomalous, but notwithstanding that, it's the only actual information I have to bring to bear today. The average award in a wrongful discharge, as it's called there, in California last year was over $500,000. So if those are the best precedents available to the juries, you might have some difficulty if you act for the employer. Let me deal with the issue of costs from the standpoint of the employer. Now, I'll be talking both about costs being reduced or not being provided if the employer succeeds, and solicitor and client costs being awarded if the employee succeeds in the same breath as the same factors. John said, ask for employment standards minimum, and if you don't get it, plead it. The courts have awarded solicitor and client costs are not provided. Or again, when the employer has one, provided no costs at all. They've awarded solicitor and client costs when the employer behaved in a manner which the court considered objectionable or appalling. When the employer acted fraudulently or disregarded what legal rights the employee clearly had. When the employer made unfounded allegations in the statement of defense. So it's one reason to be wary when you make allegations to the defense where you simply lose, but you must be far more wary for a variety of different reasons if they're simply untenable, although there have been cases where that hasn't occurred because the allegations were withdrawn prior to trial. Reference checks. When negative references have been provided to employees, significant cost sanctions are followed when the negative references were not deserved. Allegations based in the Human Rights Commission. Madam Justice McLachlin talked about that. I simply want to say that the Supreme Court of Canada, Badaria, I think, and obviously it's arguable, and obviously the court might well now deal with it differently, but the Supreme Court of Canada in 1980 took the position that any action that could be encompassed within the Human Rights Commission, which certainly encompasses sexual harassment, cannot found a civil case in any form. So proceed with caution insofar as there may be an action to strike that portion of the claim or the claim entirely, depending upon what specifically is dealt with. Another issue that arises sometimes is when you're dealing with a civil case and there's a contemporaneous human rights action or a contemporaneous Canada Labor Code provision in the federal jurisdiction. And remember this if you act for plaintiffs. if I could just intrude on John's territory
Go
for
for it. It's a good point.
thank you.
It's a good issue.
Think about the Canada Labor Code. I've had even experienced, we act for a lot of federal jurisdiction employers, just as it happens, and I've been surprised by even some specialist employment counsels suing my employers civilly because obviously it simply didn't occur to them that it falls within the Canada Labor Code. If it falls within the Canada Labor Code, it's much less expensive, it's much more expeditious, and the remedy is 10 times, to use a phrase, as powerful. It provides the opportunity of full reinstatement and back pay. Now what happens when there's an order of reinstatement? Do you think the employer really wants to take that employee back, especially after a 10-day Canada Labor Code adjudication? So what invariably flows from that is an offer of settlement to the employee, not just what was awarded by the adjudicator, but perhaps another year not to go back. And that's really the understanding of counsel going in 95% of the cases. That's what's going to happen. So think about that prospect. But in any event, to get back to my primary point on this issue, if there's a contemporaneous Canada Labor Code claim or a contemporaneous human rights claim, or for that matter, any other statutory remedy that deals with the dismissal itself, bring a motion to stay. There's a variety of cases on point, the most recent one being Adams and Rogers Cable about 2 months ago, dealing with the stay of the civil action because of the Canada Labor Code contemporaneous claim dealing with the very same matter. The last point I'll deal with because of the time from my paper is the examination for discovery. 2 points. Too many counsels simply look at examination for discovery as an opportunity to ascertain what the company's position is, and I think that's a throwback to the rules of up until 3 or 4 years ago. It's a time to get admissions. It's more than just a time to do a fact-finding exposition. Furthermore, if you're going to get admissions, I'd much rather do an examination for discovery, where the plaintiff is much less prepared, and your client has invested far less monies than a trial where all aspects of the case will have been considered, their witnesses will have been consolidated, and they're ready, and less likely to make those admissions. And the rules of evidence, of course, are in some respects more circumscribed at a trial. I'm just going to deal briefly with a couple of John's points, which were excellent and very helpful to myself as well. The danger of making too individual a statement of claim without a great deal of care is it provides the opportunity in many cases for the defendant to bring costly and delaying motions. To some extent, the advantage of standard form claims that have been tried and tested through many years is that there is not going to be the opportunity for that form of successful motion. With respect to a mental distress claim, I have the same concern in light of Vorbis, and as well, it opens up issues for significant inquiry and examination for discovery, and even though some of it is protected by OHIP, obviously the medical report is not, and the chance of succeeding, except in the most extreme cases, is so limited, I'm not sure if it's worth the value from the standpoint of the employee. The last point I'll make is that pleading to age 65 may well contravene the Master and Servant Act and therefore could lead to a motion to strike. What you might want to do, taking the very same point, is simply plead the understanding the employee had a very long-term service and they wouldn't be terminated at that stage in their career. Anyway, thank you very much. Nancy, do you want to come up? Why don't we take 10 minutes of questions to any of us, from anyone who wishes to.
I'd like to ask a question just on the Canada Labor Code and the section, I believe it's 240, remedy to be reinstated. Under that section, it excludes managers. How narrow has the board defined manager?
Okay, the first point I'll make for the three of us is that any of us can be free to answer any questions that's asked, whoever it's addressed to. So I'll answer this one at least initially. For those of you who aren't familiar with the provisions of Section 240 of the Canada Labour Code, the unjust dismissal remedies that I referred to, there's first of all a host of exclusions. Employees under 1 year, employees who were terminated as a result of discontinuance of function or layoff, just cause, and the managerial exclusion. Now, the managerial exclusion is not what you might expect, as the questioner alluded to. It's been defined very narrowly to only exclude employees in a senior policy-making capacity at that particular company. It's different from the standard supervisory exclusion, for example, in the Labor Relations Act and the Employment Standards Act. So, although employees may well be supervisory and may be entitled to management or a manager, they probably, well, unless they're senior policymakers, they probably have access to the remedies in the code.
Can the employer claim a credit for monies paid under the Industrial Standards Act?
Well, if I could, the Employment Standards Act, the case of Brown and, case I did, Brown and Black-Lawson Kennedy of Mr. Justice Lissaman said they can't take it, it is a credit.
It is a credit.
And there were two other cases saying it is a credit, but a recent divisional court case said, well, gave leave to appeal, so we'll see.
A big issue.
One comment from a plaintiff's perspective on analyzing from a plaintiff's perspective on analyzing a wrongful dismissal action. I think one of the most important factors for a lot of people, particularly those that are dealing with this area on a regular basis and are therefore usually dealing with employees that are not high-income earners, that are in the middle to lower-income area, is to recognize all the discounts that will take place when you ultimately achieve a settlement. For example, the obligation to pay back UIC benefits, the tax consequences on the settlement, and thirdly, of course, is the legal fees. And often, when you've gone through that analysis, you had started with a case that looked like it was reasonably pursued. Once you've taken off all of the other items along the way, you're talking about virtually no money at all. And I think it's important for people to do that analysis up front, otherwise they're going to be for a rude surprise when you settle the case and give the client a large bill and you discover the client's going to be nothing.
I mean, I agree with that. I mean, I think that's why a reasonable Rule 49 offer right at the beginning is really the only way to address that. You've got a tremendous economic inequality when you're acting for plaintiffs like the kinds of plaintiffs you're talking about. I think you make a good point.
In the Mitigation cases where the position of the employee was changed and it was held that the employee did not mitigate his damages, what does the employee do in a case like that? Sue at the same time as still being employed there in the position, see how it works out? Or once the court in effect states that the employee hasn't mitigated their damages by at least trying the other position, what is the alternative to that?
Is accepting the position and being gainfully employed while you look for alternative employment that is more palatable to you.
There have been a couple of cases. There was a Court of Appeal decision in around, very early in any event, about 60, and I think it involved a township, and I simply can't remember the name, maybe the town of Walkerton or something, but I'm not sure. It said there was a possibility, and the courts have said this in obiter a couple of times, there's the possibility if there's income reduction, which wasn't the case in the Mifsud case, so of course Nancy's answer is the only answer in the classical constructive dismissal case, but if there's an income reduction, you can continue working and sue and treat it as not a fundamental repudiation, i.e. a constructive dismissal, but simply a breach of contract.
Is there any law on whether, I was intrigued by this jury notice discussion, and I'm surprised, given what you said, that there aren't, employers aren't routinely serving jury notices. That's not my experience in any event. But what I'm interested to know is, does the law, has the law yet been settled as to whether or not the judge instructing the jury or counsel is making submission to the
I'm not sure I know the answer, but I don't see why, it seems to me a council ought to be able to suggest a reasonable notice range.
Because that would take some of the uncertainty potentially out of what a jury might do with a case.
You mean-
Might disabuse them of the notion that this case would be, you know, employment standards, minimum employment standards.
I mean, can the judge give a range,
Yeah.
just as in personal injuries cases?
I don't know the answer to that either. I would think that might be usurping the function of the jury to some extent. But that's purely speculative.
Do you always give the jury notices?
Me?
Yeah, after you report it?
No. I think it's dangerous. Notwithstanding what I said, I think it's risky.
Point proved.
I'm just giving I said there's the empirical experience and then there's what might happen.
You had one of those rare cases in which an employee mitigated by carrying on and then sued the employer. Would it not be argued, especially in a relatively small organization, that lawsuit itself is repudiation of the employment relationship? That's effective. It's not a resignation, but it's cause for dismissal.
That's a tough question, huh?
How can you honestly serve an employer if you're taking the court?
I'll deal with my view of that. There's one decision, I think it was called Helbig and Oxford Warehousing. It certainly was a decision that went to the Court of Appeal in any event, if I haven't named the right one, but I think it's Helbig and Oxford, in which that's precisely what happened. A president of a company sued based on his view of certain patent rights he had vis-a-vis his employer, and the court said his suing put him in an effective conflict of interest position with his employer, and therefore it was cause for discharge. However, my view is generally that would not be the case. Generally, if the employer violates a legal right of the employee, it's not a conflict of interest or breach of any duty of fidelity for the employee to sue to sustain that right, any more than it would be for them to go to the Employment Standards Branch if they weren't paid their minimum wage or overtime pay or anything else. And I can't see a court finding that. Now, I think the Helbig case is anomalous only insofar as it's the president of the company and their fiduciary duties that are pertinent. I don't know if either of you want to add anything to that speculation.
I agree with that.
A question for Mr. Laskin. You have suggested in your presentation that it's often advantageous for an employee to avail themselves of post-placement services offered by agencies that paid for by the employer. Are you not taking the chance of exposing an employee to a situation where entering into, say, a salary continuing settlement that requires the employee to diligently seek alternative employment during the salary continuing period, from having an agency compelled to produce confidential notes and reports to the employer on the progress of that job search that may then be used against them?
I guess you run that risk, but I mean, it seems to me that there are tremendous compensatory advantages in an appropriate case. I mean, when all is said and done, I mean, you want your client to get back to work sooner rather than later. This isn't a game of getting a lot of money. This is a game of getting your client another job. I mean, that's what's devastated your client. So I think anything you can do to promote that is better. I mean, if you've got a decent client who's going to make a diligent search, why be worried? I mean, I don't know. That's my view.
Yes?
I'd like to address this to both the employer and the employees. When we have a situation where an employer could be in a position of offering either a lump sum settlement or salary retainers, and the employee feels that the settlement has been offered as mandatory, there's a self-discussion, conflict going on. What's the better point of view? From the point of view of the employer, should the salary continue to be paid during the time of the disagreement? From the employee's point of view, should the employee accept salary continuance during the time of the disagreement?
Well, from the employer's point of view, the view I take is you pay employment standards minimum for all of the reasons I gave earlier. But that may be the employer employee's only legal right, because they may well mitigate. So I think it would be foolish and would certainly vitiate any bargaining power that you had if you simply paid it notwithstanding that. You put it in as an offer to settle, so you have the cost consequences of that, and you don't pay to put the economic pressure on the employee to accept your settlement. And I don't think a court is going to look adversely on that, because A, you've offered more, and B, you pay the statutory minimum, and after that they may not have a greater entitlement anyway.
I mean, I think there may be unusual cases where you don't want salary continuance, but to me, I mean, keeping a steady flow of income in your client's hand becomes very important when you're out of a job. You can continue to negotiate on the basis of having money coming in. I think in almost every case you're going to want to do that.
Yes.
I'm interested in the comments you had on the effect of things you put in the pleading, especially to do with cause and so on. One of the things I would appreciate some comment on from both perspectives is the issue of alternative pleading and the effect that can have in an action, especially one that will end up at trial before a judge or a jury. For example, an issue where a wrongful dismissal case is initiated and in the defense you see the first line of defense that there was a resignation tendered, and in the alternative, if there wasn't, he was wrongfully dismissed with cause. What the effect of that sort or other sorts of alternative pleadings are in your view?
Acting for a plaintiff, I love to see those pleadings. I mean, personally, I love to see those pleadings. I, in almost every case, am quite happy when a defendant pleads just cause or pleads in the alternative like that, because I think in almost every case it's going to come back to haunt them. I mean, I think it's sometimes he's too smart to do it, but there's a knee-jerk reaction from a lot of lawyers who just put it in and then regret it after the fact. And if you're good about it, you can make a lot of mileage out of it before a judge.
How so?
Refer to the pleading. Refer to what your client had to put up with. Refer to the fact that they made all these allegations of just cause and they weren't able to prove one of them. Where's the documents? Where's the evidence to prove just cause? I mean, you know, this is a game of painting your client as the good person and the other side as the bad person. I mean, whatever we may hear from our appellate court judges, the reality is that all of these cases, almost every case, is decided on its facts. I mean, almost every case is fact decided, and even up in the Supreme Court of Canada, where they're really making law, I mean, if you listen to a lot of the judges speak, they will tell you that the law they make is very much colored by the facts, even in that court. So when you're talking about a trial division, you're talking about the facts. And I mean, I think we as lawyers do a great disservice to our clients to spend all kinds of time researching law in the libraries. We do a much greater service to our client to put forward the best case we can on the facts and develop the factual basis. Law will take care of itself, don't worry. The judge is going to decide first and foremost. I mean, I was struck years ago when I was a young lawyer. I heard a talk by Mr. Justice Morden, and he talked to us about the process of decision making for him. And he said, as far as he's concerned, it's a two-step process. And step number one is, what in my gut is the right result? And step number two is, now how am I going to find a way to reach that result? No, but that's not meant to be a facetious comment. That's a natural human reaction, and that's the way most judges react. And it's only a rare case where the law is going to prevent you from getting to the result that you in your heart want to get to and believe is right. And the consequence that flows from all of that is that you should be concentrating on the facts. I mean, I don't know, that's my own theory of trial litigation.
I remember a vice chair of the labor board told me once a story, one of his first cases, and in the labor board there's someone ostensibly representing management and somebody ostensibly representing the union movement at the board. So it's a tripartite panel. In any event, he said after hearing the case, he decided that something was the correct legal conclusion, and both side members disagreed. And they said to him, well, we're not going to have the first historical decision where the chairman goes one way and both side members go the other way in favor of the union. So let us tell you the realities. Notwithstanding what the right law may be, this is the reality of this particular case. This is how you're going to rule. And so he did. Thank you very much for your participation. And we're going to, because of the time, we'll shorten the lunch hour and we'll meet back at 1:30.
You're good.